It's a wild case. Let's bring in our guest for this hour. National trial attorney Mike Jaafar is with us. And, this is a case where a defendant just can't seem to get along with the attorneys that she's been assigned. And after number 8, the judge basically said, you're doing it on your own. And today she is arguing for the first time as her own counsel with a motion that she crafted from her prison cell, asking for this standby attorney scenario. And that's a good sign for her, correct, Michael? And that she understands that there is this possibility and that she might have a hand to hold during what's going to be a very difficult process.
I have many thoughts on this. First and foremost, she probably used ChatGPT to craft a motion to allow the judge to force the judge's hand. And I've seen defendants do that, and these motions come out very, very, very artistically and very well drafted, as though they were done by an attorney. But then once you're on the record, the real person comes out, and the real Sarah Boone is going to come out. It's not going to be the words that are popping out of the page. It's going to be a totally narcissistic mental health type of display, because it has to be mental health for her to fire 8 attorneys. Now, what I will say is, this is very important. Judges want to make decisions that prevent cases from coming back. So I believe the judge is going to allow her to have an attorney on standby, if for no reason other than for her to just fire that attorney and the judge comes back and says, hey, I gave you everything you wanted, now the charade is over. Because it's actually a good move to ask for an attorney on standby. Look, you have every constitutional right to defend yourself, confront your witnesses, put together all the evidence, and put together a defense. You have every right to do it. So the judge is not going to come in and say, you cannot have an attorney on standby. The judge could say that, he'd be justified, but I don't think the judge is going to do that, because the judge, if you think about it, what happened after she fired attorney number 7? The judge gave her attorney number 8. And why did he give her attorney number 8? It's not because he thought it was going to make a difference, because the judge had already said, I'm going to go ahead and try to control this process and manhandle this defendant, because this defendant is commandeering my courtroom for her, and she's just having fun. She's just having a show. This is part of the show. He has to hear this motion. I think he's going to grant the motion, but that's why he would grant it. Those are my thoughts on the case as it stands now.
Let's watch Sarah Boone after the 911, the first responders show up. They've now determined that Jorge Torres is dead, and the police are there, and the body cameras are rolling, and Sarah, who's not drunk anymore, is trying to explain what happened.
Puzzle that we started in there.
Okay.
We've been doing art, trying to take the stuff off the wall to make new art put up there, like having a good time with one another. But we're drinking. We had a bottle of wine last night.
Okay. Fine.
So then it's like we decided to play hide and seek, right?
Okay.
So he gets in the suitcase. Okay.
Who is this guy?
That's my ex-husband, my former husband.
How did he lives here with you guys?
No, I called him over here.
Okay. Okay.
I didn't know what to do.
Okay.
I didn't know what to do.
Okay.
So then he came over here.
Here, let's talk in private, okay?
I called you guys. I tried giving him CPR. The problem is I fell asleep. I fell asleep.
When did you do CPR?
This morning, when I found him.
Before you called?
Yes.
1 o'clock right now.
I tried. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs, and I was like, oh, he's in the suitcase still. And that's when I found him, and I took him out, and I tried doing CPR, and then I called him, and then I called you guys.
Did he get here before the fire department got here?
Who?
Your husband or your ex-husband?
Yes.
Okay. Where does he live at?
Right down the street.
Okay. So you were playing, and who did come up in?
I did, but then I fell asleep.
Okay. You're okay. I wasn't here. I'm just trying to figure out what happened.
I fell asleep, so I don't know if he suffocated or like had an aneurysm or a heart attack or what.
What kind of medical conditions does he have?
None that I know of.
Nothing that you know of.
None
You didn't
that I
take
know
any
of.
medicine?
No.
No medicine.
All we had was a bottle of wine. Literally, just a bottle of wine.
Okay.
Doing puzzle artwork. Then we decided to play hide and seek. That's all that happened.
Still my favorite line. Oh, we just had a bottle of wine. There's a lot more than that. But her defense is, I mean, this seems like it's an he got into the suitcase clearly by himself, or with her help. She didn't stuff him in there. There was something going on, and she was intoxicated. What if you were representing her? Let's say you could actually get along with her and represent her. What would be the defense strategy, knowing there's video of this guy in the suitcase before he dies, and then this video of her talking to? They're trying to explain this thing away.
Strong strategy on this one, and I love this question. I've debated this. This is a law school exam question. So here's why. She's charged with murder too in Florida. That does not require any type of premeditation. It doesn't even require what's called a specific intent to murder a person. It requires a very, 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 you have to demonstrate a disregard for human life, right? If you're being charged with it, right? So here's what the defense strategy would be. First of all, you have to contend with the fact that this guy is on tape, and I'm assuming some of the members of the jury are claustrophobic, and they're just going to tune this out, right, as one of the most horrendous ways to die. The defense strategy would be this. There's a theory in the law. It doesn't apply directly here, but if you're a stranger and you see another stranger drowning, and that stranger tells you, please, give me your hand so I don't die, and assuming you're the only person there, and assuming you know that you're the only person that can save their life, and you decide not to do it, is that considered murder? Was it your duty to rescue that person? Some people would say, no, it's not your duty to rescue them. You're a horrible human being, but it's not your duty. You're not a murderer because you didn't jump into the water and save that person. This is slightly different, but I would go down this theory, which is, what was her duty? He clearly went into the luggage on his own, of his own volition. He's much bigger than her. He's much stronger than her. I still don't know how a grown man can squeeze into a suitcase. This is the first time I've ever even thought that that could happen. But he went into that suitcase willingly. He let her zip it up willingly. There's no video of that, but the defense would be, look, he went into that suitcase. She had no idea. She's a complete idiot. She had no idea. My client is dumb, one of the dumbest people in the world. She had no idea he'd suffocate. He wanted to go in there. He told her he'd done it before, and he wanted her to put him in there, and she fell asleep. It wasn't her job to unzip the suitcase. Obviously, that would be a very strained defense, but that would be your defense against murder too. I think there's no chance that even the best attorney could get her off of any crime. She would have to do some serious, she would at least be aggravated manslaughter at a very minimum, right? But that would be your defense attack on murder too if your client was rational, intelligent, was with you, was taking your advice. She has no shot of that, though.
It feels like at least some of her attorneys likely would have had that exact same thought process with her and say, hey, let's enter into a deal here. You're going to have to do, some time. And that might be the crux of why she just can't get her head around this. Eventually, she's going to do enough time in the local jail that, she's going to get there eventually to where I think a plea deal would have already been on the table. So if you're prosecuting this case, what's the most, that video of him in the suitcase, I guess you're pulling that out right away. And because to your point, has to be one of the worst ways to die. If you think about the torture of knowing that there is someone right there that can stop this, and you are losing, you can't breathe. And Sarah is right there talking and taunting you.
Yeah, I know people, Ted, that won't even go in an elevator. Okay? I know people that do not go into airplane bathrooms, right? Because claustrophobia is a real thing, right? I'm claustrophobic, so I can sympathize with people who watch that video and cringe. Anytime I've seen this video, I've had to look away because it takes you to a very, 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 you're out of breath just watching the video. And so you would be whipping out that video. The prosecution in this case are going to focus on murder too, and they're going to tell the jury in their opening statement and in their closing statement, we do not have to show a specific intent to kill, because even without an attorney, she's going to come in and say, look at what the video shows. The video shows that he got into that suitcase on his own. He did it on his own. He willingly went into that suitcase. I'm an idiot, right? I'm stupid. I did not know that you could die being in a suitcase, especially when you wanted to go into the suitcase. she's going to say that. So the prosecution is going to know she's going to do that. They're going to anticipate it, and they're going to deal with what they have. They're going to, when you make a dinner, you use the ingredients that you have in your kitchen. And what do they have? They have this video of him suffocating and telling. If he didn't tell her in that video, "I can't breathe, take me out," this is not a joke, the video would not have been as impactful. Just imagine him going into that suitcase on his own and laughing and joking, and he was drunk and he passed out and then he woke up dead, right? The video would not be as impactful as it is. So the prosecution is going to focus on this video. They're going to focus on the element of second-degree murder in Florida, which does not require a specific intent to murder a person. And I think they're going to have a victory on this, because look at who's on the other side. Just a complete just a mental health puddle of mud.
Yeah. And one of the things she says to the officer on that body camera is really tough, because she says, "I was awake, but I didn't get out of bed until 1 o'clock," meaning she went to bed. She went to bed with him in the suitcase, and he had already articulated that he couldn't breathe multiple times. It's not as though she fell asleep on the couch while he's in this. No, she went to bed, and that was... Yeah. A conscious decision to let him sit there in the suitcase all night. And so again, horrible way to go. Michael Jaafar still with us. Smoke is going to come out of the jurors' ears, and possibly if she gets comfortable, Daryl Brooksy, like representing herself. It could be because she has one of those personalities where she keeps talking and talking and has an answer for everything. This is going to be something to see.
This is a person who wants to be the center of attention and wants to tell her story, and not in a good way. That's the worst type of defendant to defend themselves, right? Which is why defendants almost never defend themselves. Once in a while, it'll happen. And it usually happens with a person who wants to have their grand courtroom moment, right? And so, you know, I keep thinking to myself, this is an imminently winnable case on the murder, too, if she was a rational person, which she's clearly not. And I'm thinking about something you said on the first block, which is probably her attorneys concocted some sort of a plea deal, which makes total sense, because she should serve some prison time. This is at least an aggravated manslaughter in Florida at a very minimum, right? Because you still had a hand in the person going into the suitcase. It's different than the analogy I gave earlier, where you're a stranger and you find another stranger drowning and you don't rescue them, right? That's different, but that's the theory. That's where you go as an attorney, right? In her case, she had a hand in him going into that suitcase. Again, he had a hand in him going into that suitcase. He had to cooperate even more than she did, because he had to contort himself into the suitcase. But she, you know, she wants to talk about herself. She wants to be the center of attention. And I know why she wants to be the center of attention, because she feels like she's a victim. And when you go into the courtroom in a trial context thinking that you're the victim, you've lost already. Once you go in and you're not prepared for battle, which is what an attorney does, they tell you, listen, you got to cover up the tattoo on your face. You got to brush your hair. You got to wear this outfit. You got to be nice. You got to put on glasses. You can't look menacing at anybody. People are going to say bad things about you. When they say bad things about you, you cannot react. You need to cry if possible. You need to be emotional whenever an emotional witness is on the stand, even if they're saying negative things about you, right? You have to do that. She robbed herself of all of that. She's going to have none of that. She's going to go into this courtroom, look at me, and guess what? People are going to forget about her when she does 25 to life.
Yeah, and representing herself is going to add a totally different, because the way you're describing it as, you know, her being a defendant, if she was listening to an attorney, you know, she's got a decent chance of saying, I didn't realize a guy could die by being in a suitcase, and I was really drunk. And you can hear how drunk she is when he's pleading with her, let me out, Sarah, and she's like, you should have thought of that before you cheated on me. She's blitzed, and that could be, you know, helpful. But if she's now presenting her own opening statement, and this is going to be bad for her. Is there any way, I mean, I know the judges said, listen, you have to now represent yourself. If she were to come to the court and say, give me one more chance with a public defender, do you think that that's an option?
Yes, she won't do that, but yes, the judge, because the judge wants nothing more than to be done with this case. And the judge is going to be done with this case if she has an attorney for two reasons. Number one, the case is going to be a lot more efficient. It's going to go fast, right? The worst thing for a system is a pro se defendant. A pro se defendant prolongs the process, makes the process clumsy, and judges are not equipped to. When you look at these trials on TV, right, they look like orchestrated symphonies and ballets, and they're so well choreographed by both sides, and the questions and answers and everything is so crisp. And when you don't like it as a judge, you say, come get a sidebar. No judge wants to take a sidebar with this lunatic, right? So for that reason alone, the judge is going to say, yes, you can have another shot, but you got to prove to me. But then the other reason is the case is probably not going to come back on appeal, right? Even with lawyers, sometimes it comes back on appeal. That's how frayed this is. There's a higher chance of it coming back on appeal if you defend yourself, because now you have just yet another piece of red meat to throw everybody. But you've also robbed yourself of the defense of being stupid. I can't tell you how many times, my first year as an attorney, I got a client in a meeting with the FBI. We say, hey, he's just an idiot. He's a complete moron, and no charges were brought against him. There's just a lot of stupid people. And this lady is a stupid person. And she robs herself of that entire thread of thinking, because she clearly is an idiot. I don't believe she intended to murder, Jorge Torres with that video. I think she was just a complete moron and a criminal, but not a murderer. So I think the judge will say yes if she says, give me one more shot. I don't think the judge can say no.
Yeah, and to your point, I don't think she's going to ask. So we'll see. We'll get a break in here. Michael Jaaffar's with us. What should be done here? It seems as though the jury didn't fill out the verdict form. They should have written in not guilty for those two. What will happen? What should happen, in your opinion?
Very, very, very simple. This is actually not a complicated one. What needs to happen, and what I believe will happen, is that the juries need to be questioned whether or not the form was filled out properly, because because double jeopardy doesn't apply just because a form is filled out the right way. It applies if 12 of your peers unanimously agree you were either guilty or not guilty. That's when double jeopardy applies. So this is the first time I've agreed with the defense attorneys for Karen Read, because as people know, I hate this woman. She's a con artist. This whole conspiracy was a hoax. But I actually agree with them here, right? If in fact these 12 jurors did in fact unanimously agree to acquit her on the murder 2 and the leaving the scene, she should not be retried for it. The double jeopardy and your legal rights don't say, well, it's required for you in 230 years after the Constitution was framed. We want people to handwrite or type things out the right way. That's not the way it works. The way it works is 12 of your peers have to agree unanimously. And if 12 of her peers unanimously agreed, those charges are done, right? The way you do it is you question the actual source. They have 4 jurors who are saying that. Those 4 jurors could be saying the truth, or they could just be gossiping, or they could be looking for attention. We don't know. There's only one way to know. You got to ask all 12 jurors. So I think the defense, part of their motion, they're asking to actually not voir dire, but question these jurors in an official capacity with witnesses. I think that needs to happen. I'm curious. I want to see what happens. I don't believe that the murder 2 was even proven. So the fact that there was a hung jury on the murder 2, that puzzled me a little bit. But I think that that's what's going to happen. I think the judge has to. Everyone's going to want to know, especially in this case, Ted, because of the looming specter of cover-up, right? Imagine the government coming in and saying, no, we don't care what those jurors believed. The whole world is with Karen Read, but we don't care. We want to retry the case again. Can you imagine the chaos that would be? If you're a judge, you would just let them have it, let them actually question these jurors, because how embarrassing would it be for her defense if 4 of the jurors come back or 5 of them come back and say, no, we were not unanimous on this. We all want to know, and so the judge should just let them figure it out.
Would you, if you're representing Karen Read, accept if Prosecutor Lally shows up on Friday and says to the judge, we don't plan to retry her on the murder 2 or the leaving the scene? But would you accept that, or would you say, no, Judge, we need a not guilty recorded somehow, some way, so that she isn't exposed down the line?
You never, ever reject a nolo contendere, just a no prosecution. We call it nolo, right? You would never say no to that. If a prosecution says, we're not going to, now listen, prosecutions can come in and say, we're not going to prosecute you for now, but we're going to reserve the right to do it. I don't think Lolly would ever come in and say, you know, I guarantee you we're not going to prosecute her again. I just don't see that.
Why wouldn't he? I mean, everybody seems to agree it was overcharged, that second degree. At this point, given just the turmoil of the town and the sort of eyebrow-raising, you know, conduct of some of these investigators, if you're Lolly, why not just say, listen, all right, no second degree? Because you're not going to win it. You could do it 100 times. I don't think you're ever going to get a second degree, given the cast of characters that you're relying on to prove it beyond a reasonable doubt.
While I agree with that, the only problem in this case is such public spotlight, and prosecutors changed hands, and there's no statute of limitations on murder too. She could always be charged in 10 years. And what if she wants to write a book? And what if she wants to tell people, hey, I didn't do this? You just never know. But yeah, of course, you're never going to say no to that. If you're the defense attorney and they say, we're just not going to recharge her on the murder too, well, that does leave in the scene of an accident, which, by the way, still puzzled me. But that leaves that on the table, and so I feel like you're too late in the game. And if you're the defense attorney, you do have a winning hand on the murder too. I think you're going to want to see what the jurors came back with. I just don't think it could be like a horse traded type of situation where if you drop your motion, we're not going to retry her, but we will retry her for the leaving the scene of an accident. Perhaps her defense attorneys will go for it because that would kind of be on brand for Karen Reed. But even the state now believes I shouldn't move forward, so they won't say no to it. But it would just be a clumsy type of thing. And also, one more thing, Ted, there is going to be another trial on the hitting him unlawfully with a car. And if the evidence comes in that trial negative against Karen Reed, or if there's another witness or more evidence that comes out, the murder two would come back to life. They could then recharge the murder two. So that could happen. So her defense attorneys know we're going to be retrying this case anyway. And in the conduct of that case, our client might make a mistake. Some defendants are stupid. She might say something to somebody else, and then she would resurrect the murder too. So that's why it's fraught with peril. This is like an airplane that reaches V2, which is the speed at which it can no longer safely abandon takeoff. This airplane has reached that speed. It can no longer safely abandon its takeoff. This is a crash or a landing. Either way, it's got to take off. The die is cast, and we have to see how this plays out. But yeah, crazier things have happened.
Yeah, absolutely. And we'll find out on Friday. Again, all the parties will be back on Friday, and the judge is going to have to come up with a game plan here. The Commonwealth doesn't recognize a verdict if it hasn't been recorded, and they didn't fill out that verdict form. Does that mean that there was no unanimous decision? It sounds like there was from jurors. You at least need something on the record, right, from the jury foreperson or something, because at some point, if she's ever convicted of murder two down the line, which is highly doubtful, the federal government's going to, you know, a federal appeal will come in here and say, all right, this never should have been charged the second time after knowing what they know, right?
Yeah, no, 100%. We're talking form over substance, right? It doesn't matter how they recorded the thing. If they were unanimous on anything, they can easily reconnect, get everybody together in a room. Case is technically, it's not over, right? Because the judge ruled a mistrial, but again, the judge will be happy to say, hey, you know what, actually there was not a mistrial on this charge. Let's everybody get back together and let's see what the evidence are. The defense has to convince the judge that the actual process did not work, and if they convince the judge that the process did not work and there was defects in the actual forms, we're literally talking like paperwork, right?
They just didn't fill it out. I mean, they sat around and they thought, okay, we're deadlocked on this one thing, so we're deadlocked on all.
Yeah. So the judge will bring them back. I don't see in any part of my imagination that the judge would say, I don't care, I've made my decision, let's move on to another trial. This judge, as if we recall, she kept admonishing that jury to go back into the room. And this is another factor of this. Go back into that room. I'm going to buy you more food. We're going to spend more time. You guys need to really, we've put a lot of witnesses. You know, the state put on witnesses for 28 days. I need you guys to go back. So I don't think this judge is going to balk at kicking out the murder two, because the second trial will be more streamlined, right? Even if they can kick out the big murder two charge. But crazier things have happened. This judge could come in and say, look, I gave you guys every opportunity. You guys are all idiots. I sent you back into the room 3 times, and you still came back and you did not know the definition of a unanimous verdict. And they can come back and say, well, you never gave us the instructions. Hey, crazier things have happened.
Absolutely. We'll see Friday. We'll be here. Our Matt Johnson will be up there, and we'll be watching together. Let's